Hi, I'm Ozlem Gurses. I'm an associate professor of law and I teach international commercial insurance law. In this video, I'm going to introduce the subjects included in this course. Insurance is an essential element of nearly all commercial transactions and of many situations that private individuals encounter. The United Kingdom insurance industry, with its centre at Lloyd's of London, has an international, indeed worldwide importance. It's a subject with long historical roots, but is also going through a period of change and reform, making this an interesting time to study the subject. This course will enable you to study the development of commercial insurance law and to engage with the cases and problems that will give you an understanding of the reality of decision making and problem solving in this field of law. The course is divided into 4 modules. The contract of reinsurance, reinsurance losses and claims, liability insurance, conflict of laws in insurance. The contract of reinsurance introduces you to the key concept of reinsurance, which allows insurance risk to be spread, thereby enabling insurance to accept risks that would otherwise be beyond their capacity. Reinsurance is a contract between 2 insurers, in other words, insurer and reinsurer, by way of which insurers share the risk and the premium so that insurers may expand their insuring capacity and also keep themselves solvent against large risks. In some countries, only local insurers are permitted to insure local risks. In such a case, a local insurer may insure the risk locally and then transfer 100% of the risk to a reinsurer in another country, possibly in London at Lloyd's. This is called fronting. A local insurer acts as a front for the reinsurer. The English judiciary have developed the principles applicable to reinsurance contracts over centuries. Since most reinsurance disputes are litigated in England, and English courts have long established principles applicable to reinsurance contracts, it is often seen that courts in other jurisdictions refer to English law to determine reinsurance disputes. It's important to learn, firstly, the procedure followed to form reinsurance contracts in London, and where the reinsurance contract terms are found, and how such terms are interpreted. Reinsurance contracts are commercial contracts, and the rules that apply to interpretation of contractual terms play a very important role in determining reinsurers' liability, which we'll look into in this subject. Very much linked with this topic, we will move on learning the rules governing reinsurance losses and claims. This topic covers some fundamental principles that apply to reinsurance contracts, such as the presumption of back-to-back cover. This principle explains again how to interpret original insurance and reinsurance contracts together. We also analyze the follow the settlements clause in reinsurance contracts. These are very common clauses because they set out rules as to how a reinsured proves reinsurance liability under the reinsurance contracts. If we start from the beginning, the contract between the assured and the insurer is the insurance contract, and when the insurer in this contract reinsures the risk, the contract between him and the reinsurer is called reinsurance contract. The insurer, in other words, the reinsured in the original insurance contract's liability under the original insurance, will then lead him to make a claim against the reinsurer. We are going to learn whether the reinsured may make a claim on the basis of a judgment or an arbitration award against him, or whether he can also make a claim on the basis of a settlement reached with the assured. Moreover, a reinsurer who would like to retain control over the claim under the original insurance contract may include a claims provision in the reinsurance contract. It's important to understand the relationship between claims provisions and other terms of the reinsurance contract, since breach of a claims provision may create draconian consequences for the reinsured. Liability insurance is a type of insurance contract that covers a wide range of topics. A typical example is a motor vehicle insurance, which we all are under a statutory duty to take out before we drive a car on roads. Employers in the UK are required to insure their liability for bodily injury or disease sustained by its employees and arising out of and in the course of their employment. It's a prerequisite for some professionals to take out professional indemnity insurance before they apply for license to practice their profession in the UK, for instance, insurance brokers and solicitors. Not all liability insurance policies are compulsory. A person may also, for instance, purchase a professional indemnity insurance voluntarily as a safety net in case there is a third-party claim against them with regard to their professional performances. This topic, therefore, will cover the main forms of liability insurance contracts, the contracts that we are most likely to deal with in our daily personal or professional life. With regard to compulsory insurance contracts, we will look into the relevant legislative instruments imposing the obligation to take out liability insurance. Similar to reinsurance contracts referred to before, liability insurance contracts may also contain claims provisions which then may require the assured to incur costs to defend the claim by the third party upon insurer's request. It is therefore necessary to also analyse the insurer's liability for payment of the cost incurred to defend the third party claim. Conflict of laws in insurance covers the rules concerning which legal system and jurisdictions apply to particular disputes. In an insurance or reinsurance dispute, it will be necessary to determine the courts which have jurisdiction to hear the dispute. Bringing an action in a court which does not have the necessary jurisdiction, the claim might be rejected for this reason before discussing it in substance. In addition to the determination of jurisdiction, it is very important for the parties to know what law will govern their contractual relationship. Both the jurisdiction and applicable law issues may be determined by the parties in their contract expressly. If there is no determination as such, the rules on private international law will be applicable. This topic will cover the relevant legislative instruments and the case law on determining these matters.